Hi, I'm Allie Bushelli, and I'm a junior partner here at King Law Offices.
And I'm Martie Wallace, also a junior partner here at King Law Offices. Today we're going to talk about something that happens not a lot, but when it does, it causes me PTSD. Um, we have an intersection between family law and wills, trusts, and estates when a decedent is in the middle of a divorce and then he passes or she passes away. And Allie practiced family law a lot longer than I did before I went into wills, trusts, and estates. So I'm going to let you talk about that intersection, even though I'm currently in one of those right now.
Thanks. So there's intersection when you're talking about just getting separated, and then, of course, when someone passes away. So we'll talk about the real quick. Let's say you just got separated, and of course, that's an emotional time. You've got a lot going on. You're thinking about a lot of different things. You may or may not have hired an attorney. You may or may not be doing a separation agreement. You might be going to court through equitable distribution. If you've got minor children, there's custody involved. It's not a fun time, but not to be the bearer of bad news, but you should probably bring another attorney into the mix, an estate planning attorney. Part of the reason, once you're separated, you want to do that. In North Carolina, when you are separated, there's no legal separation document that's filed. You can have a separation agreement, but again, that's not filed. The only thing you would see filed is a free trader agreement. So that's when you would file with the Register of Deeds to say that you and your soon-to-be ex-spouse can make property deals outside of each other. You can buy your new house. You can sell a house that you had before without them being involved. But other than that, you're still married. Now, there's a lot of intricacies in what happens with assets, what happens with income, what happens with things after you separate that I will leave to our family law team to explain in more detail. But as far as estate planning world is concerned, you're still married. So if you ever have, or if you've never done any estate planning when you get separated, it's a good idea to go ahead and start doing that now. If you were to pass away while you were still married but separated, technically your soon-to-be ex is your surviving spouse, and they have certain rights that they can try to assert against your property, and real and personal property. So they could say, well, I'm entitled to $60,000 off the top of all of the personal property, which includes money in the bank. They can say, well, I'm entitled to so much of the real property that wasn't in my name. I'm entitled to this and this and this. Well, that's not what you want. You're getting a divorce. Like, that's not what you want to see. So if you don't go the separation agreement route, waiving all of those things, which I would always advise is the best thing to do, if you and your ex can come to an agreement. Now, you're getting separated for a reason. There's not always a lot of agreement there, but if you can, just make sure that your separation agreement includes waivers of elective share and spousal allowance. Those are the two big ones. And any attorney that's worth their salt is going to have that kind of baked into their documents. I know we do here. So our separation agreements include those waivers. That just means your spouse, well, you're separated, but before you get divorced, if you pass away, they can't claim against your estate for any money, which is what you want to see happen. If you've already filed for equitable distribution, before you pass away, you don't tend to see those claims being made. Someone crafty could do it. Usually just ends up getting put into the easy action in court. But if you're separated and you haven't done a separation agreement, and if you haven't started the equitable distribution action, your estate has a year from the day you pass away to file equitable distribution on your behalf. And that's what can prevent your ex from, taking everything and being the next of kin, being the surviving spouse. Mm-hmm. That's always a good one. Something to also do is go ahead and get a simple will done. We call them placeholder wills. It's something that you have just in case the worst happens. You disinherit your spouse, which again, they still can claim some of those things, but they get the bare minimum then. Mm-hmm. You go ahead and say, okay, I'm disinheriting my spouse and I'm leaving things to children, sister, brother, nieces, nephews, parents, whatever is in your best interest, charity. You can do whatever you want. But you want to have what we call a placeholder will. And if you go to what I call a jack of all trades firm or more of a general practice firm, like here at King, your family law attorney should be able to refer you to someone internally to get that will done. Your family law attorney very well might be able to do that for you, but it's something to consider to go ahead and say, okay, I want to just have a placeholder done. We always advise doing something more beefed up after you get divorced, after that judgment is entered. Not when you get all the money, not when your case is technically resolved, when you have a divorce judgment in your hand, because that's what's going to matter. Something to also think about is your powers of attorney. If you've never done them before, then you don't have anything. And as far as a hospital or a bank is concerned, your next of kin is still your soon to be ex spouse. Do you want that person making medical decisions for you? I wouldn't. I don't know.
I had that. It came up. I had that situation come up about 6 months ago, and their biggest concern, it was the parents, and it was again a COVID situation. It's still going on. People don't realize it, and they the parents were they were in the middle, they were separated, and the parents were mainly concerned that they could say the disposition of the body, because the doctors had told them that he's not going to make it. So it was kind of an emergency for me when they called me, and they're like, we don't want to talk to her, we know she's not going to do it. And I said, well, I think the fastest way is to talk to her. Let me talk to her and see if we can get her to just agree to it. What does she care where the body? They wanted the body buried near them. And sure enough, I called her and she was very kind to me. But that's why you have attorneys that are not trying to spur the fight.
Right.
I went very kindly. I was sweet. She knew that her soon to be ex husband was not doing well in the hospital. And I said, listen, this is the biggest thing. It has nothing to do with the finances. They just want their son buried near them. Do you have a problem with that? I framed it in such a way that she would probably feel like a terrible heel if she said yes. But not only did she was very compliant. She was willing to sign whatever it took, and she has a right, of course, to an attorney. But we were, and I told her that, but she didn't get an attorney, and everything was very smooth. So in a very sad situation, that ended up being a good thing.
Right.
And sometimes it just takes an attorney just to call the other attorney. But in her case, it was no other attorney, but
right.
It worked out well.
Right. And that's best case scenario. You can make a quick call and, everything's great. Everything works out.
A power of attorney would have been better.
Power of attorney would have been better. Let's say she didn't care. Let's say she had something against the parents and
Just
spite.
How many times did we see that? All the time.
Just something out of spite.
Yep.
I'm going to have him cremated out of spite because you want him buried. You want to have a funeral. I'm going to say he's going to be cremated. We want to think the best of people, but in a divorce, we don't see the best of people all the time. So redoing your powers of attorney as soon as you separate or doing them for the first time is a good way to help prevent that. And again, those documents can be placeholders. They don't have to be the final end all be all, but you want to make sure that, especially if it's not an amicable separation, sometimes people get separated because it's just not going to work.
Right.
And so, if you still trust them, fine. I say that kind of tongue in cheek.
Yeah.
There are times where people do genuinely trust each other. I've had clients where it's just not, we're not great partners. We are great co-parents. We are great friends. We are not good partners.
Right.
And so they trust the person to still make decisions on their behalf. They would trust them with their life. They just don't trust them with their heart, really.
There's unicorns out there.
So that's something to think about in family law. And again, talk to your family law attorney. They can either refer you to somebody in the community if they don't do those types of services. If you come to somewhere like King Law, we have a general practice firm, we have family law attorneys, and so we can internally refer and get those things done relatively quickly and make sure that there's no lapse in decision making or anything like that.
Right.
And then also, when you do get separated, get on it when it comes to filing separation agreements. It's a raw time and no one wants to be in the courtroom. I know it's not fun. You don't want to be in the courtroom in that middle of that time, but the longer you wait, the more difficult it is and the more expensive it's going to become. You do
Mhm.
have to backtrack assets, values, things like that. Again, more details for our family law team, but if you can get some things done sooner rather than later, it's better for everyone in the long run.
Yeah, I think powers of attorney, I always say this. I think powers of attorney are the most overlooked documents in people's, they don't think of it as an estate plan.
Mhm.
It's because it's not technically an estate plan. It can be if you've given those powers to your agent to be able to do estate planning for you. So I guess indirectly it could be an estate planning
It,
mechanism, but
it's
I always
part of an
involve it.
estate plan.
Yes, I
Yeah.
involve it because it has so many wonderful things that it eliminates for the family.
Mhm.
And while we're on that, did you want to talk about the difference between a last will and testament and a living will? We laugh a little bit because I love when people call it. It's cute. I don't think anything. It's like when I if I were to need to go to a cardiologist and he knows so much more than I do, and he probably thinks some of the things that I say might be cute. Well, this is very cute, and they'll say, "Well, I have a living will and I left my kids everything in it."
Right. So and again, it's very sweet. It's some common nomenclature conflicting that we see. So a living will is something that you use while you're still living for your, I'll say, prescriptions for end of life treatment. So, what level of care do you want in certain scenarios? Here we have living wills baked into our healthcare powers of attorney. And there's, certain scenarios, and, if you watch, Grey's Anatomy, you see the coma patients and someone having to pull the plug. Well, they didn't want this, and that's not what they wanted. That is someone acting under a living will. DNRs or do not resuscitate is very different from a living
Right.
will. So living will different from a DNR or do not resuscitate. Do not resuscitate is something that you'd want to talk to your healthcare provider about. And I believe healthcare providers have forms for those types of things.
Yes.
So that's something to speak with them about. Living will is okay, I'm in a coma. What level of life sustaining care do I want? Do I want my healthcare agent or your power of attorney to make a decision? And that's because you've sat with them. If it's your spouse, you've sat with them on the couch and talked about it. Your kids, you kind of told them where the line is. Do you want any life sustaining treatment? Some people say no. And then do you want the maximum? I say the maximum amount of treatment modern science can provide.
Yep.
Those are our three options in our powers of attorney. You have the ability to limit and make some very specific requests, but those are the big three that you see.
Right.
And again, your soon to be ex spouse, are they going to respect what you want done, or are they going to do what they think is best in the moment? If you have a mutual respectful relationship, they'll probably continue to do that.
Hmm.
But there's no telling. Unfortunately, the your marriage has ended and it's not something you want to think about. It's not something that's always bad, but it could have been gnarly. Do you want to talk to them? Do you want them to know that you're in the hospital? I
Hmm.
mean, sometimes it's an abusive situation. Do you want them to know that you're anywhere? That's why doing those types of things, doing a power of attorney can protect you in so many different ways. And so that's something we always encourage our family law team to reach out to their clients about, to connect with us internally. Um, it's just always a good way to think about it. Something we've also seen with family law and interplaying with estate plan is life insurance policies. Um, part of a separation agreement, or just even because you think it's what's best, you can either be compelled by the court or by a separation agreement, or out of the kindness of your heart, still leave your ex as a beneficiary on your life insurance policy. And it's not because you like them and you want to compensate them for anything that happened. That's not what usually happens there. It's because you probably still have minor children. And if something happens to you, you want to make sure that your minor children are still taken care of. They themselves can't have that money. When you're talking about someone who's a minor and that's under the age of 18 in North Carolina, they are not able to hold those funds themselves. There has to be multiple types of avenues for them to even have them in their name, custodial accounts, guardianships of minors, even for a parent to claim the funds. So you'll see a lot of times where the money is left to the parent, the co parent, in order to be for the benefit of the children. Now, just know that legally, that life insurance money is going to be your ex spouse's money to do whatever they so choose. So if you really don't trust them, leaving them that money is not in your best interest. But if you genuinely believe that that person is going to use those life insurance proceeds for the benefit of your kids, whether that's paying off a house so they can take some time off work, putting it toward college funds, putting it towards something else, you can ensure that, your minor children are taken care of.
Mm-hmm.
Something also to think about on life insurance policies, if you don't have minor children, or if you really just don't want to leave your ex spouse any room to control anything that was once yours, you got to update your beneficiary designations. That includes retirement accounts, bank accounts, anything. You need to go through and change all of those things upon being separated. If you believe reconciliation is on the table, that's very different. That's a personal choice of when you make that call to change those things. But if you have a retirement where your soon to be ex spouse is your beneficiary, you want to call the financial institution, get that beneficiary change request form, and go ahead and mail it in with your updated beneficiaries.
Mm-hmm.
You don't want to leave that to, oh gosh, it's been 5 years and I got into an accident. I'm okay, but what would have happened? That's the worst time. Or when your kids are going through stuff and they realize dad never updated all of his beneficiaries, mom's getting all of this and she's not going to share. And now we've paid 15K for his funeral and we're never going to see any of it.
Right, right. Another situation that can come about not updating beneficiaries, and I've had this happen on more than one occasion, where somebody starts at a corporation or oftentimes, well, the both times I've seen it was for a utility company. Um, One was actually Bell South. And anyway, they started at this company when they were very young, like straight out of high school. And then many years go by, and they have left their parents as a beneficiary. So many years go by, there's no will, nothing. And one that comes to mind, he had never married, but he had a girlfriend of 25 years. They lived together. She took care of him when he was sick, and he didn't account for her other than in this little life insurance policy. But his parents had passed away who he had left as beneficiary. So then when you don't have a beneficiary on a life insurance, in this case I think I said it was life insurance before, but it was actually a 401k. Like it was, and it was in the millions of dollars. And if there's no beneficiary, then we have to put that through a state administration. Well, in North Carolina, now there's going to be almost a 0.5% cost on that. And he didn't have a will. So then it's going to go through intestate succession, which means the legislature decided how that was going to be divvied up. Well, he'd never had a wife and he didn't have children. He had three siblings, one of which had already passed, and they had one child. So how that works out in North Carolina is these millions of dollars were going to be split between the 2 surviving siblings, and then the surviving child of the deceased sibling was going to take that her father's share. What was so painful was that niece couldn't have picked him out in a lineup. So she's pretty lucky to get that, but is it what he would want? And they ended up giving the girlfriend, which that was the first time I'd ever seen that.
I would not. I would have thought everyone would have taken the money and run.
Nope, they didn't. They gave her all the real property, which I thought was very kind, and car. So she have a car, but I just have a feeling, and I don't know their relationship. I never know the decedent, but I was thinking, wow, if he'd just gone to an attorney. I think that so much,
right?
Now, that I'm an attorney now, but that's another thing to think about. Make sure your beneficiaries are still alive and that you still want them to be a part of your estate planning.
Yeah, about every 2 years, kind of check in on that. When you send in beneficiary change request forms, and I say that long name because that's usually what the companies are calling them as well. Take a photo, put it on your computer, kind of so you know what you sent in. Make sure it got sent in. Sometimes they get missed. Make sure that your policy's actually been updated. And then, every 2 years, kind of revisit it like, okay, is this still what I want? It could take you all of 2 seconds to say, yep, that's still what I want. But if someone has passed away, or if you're getting divorced, or if something happens, you can say, oh, wait, no, that needs to be updated. This is the form number because I'm looking at the one I just submitted 2 years ago or 4 years ago. Like, this should be the form number. This is at least the name. The number will be on the form too to call back. It's usually a general line. Call them. They'll be able to send you another form. A lot of them do it via email too. I think a lot of these companies also have portals where you can, and financial institutions have portals where you can make the requests and they'll send you the documents. But they all have their own different policies. That's not something a lawyer can really help you with. We can help you kind of find it, but you have to be the one to go to each place and update it. And we'll always advise our clients to update their beneficiary change or their beneficiary designations upon divorce, upon someone's passing, and always leave at least 2 layers of beneficiary, a primary beneficiary and a contingent beneficiary. Someone who, okay, let's say you don't get to updating your documents and the primary person has passed away, what's going to happen? And that would be, a fail safe, hopefully. But you just want to be extra sure that it reflects what you want.
Right. Another question we get a lot, and oftentimes the question is being presented with the document, and is this valid? And that's a will. In North Carolina, as in all states, we have a statutory requirement for what makes a will valid. What's interesting is in Office Depot, Staples, you can go, and even online, you can go and, I do it yourself wills. Well, that's awesome, right? You don't have to pay an attorney to do it. How great is that? Well, it's really great until you're up in heaven. We can't call you and say, did you really mean to do this? Because this will isn't valid. So I get all the time these pre-made wills that I'm like, it looks like a lawyer drew this up, but they didn't know North Carolina law. What happened? Oh, we went to, and same with powers of attorney. Oh, I got it from Staples.
Or we went online and it populated. And Martie's right. There's, unfortunately, the law for wills is still very, I'm going to say archaic because it kind of is.
It's not user friendly. It's not intuitive.
No. And with the law for wills, because it's so old, it doesn't account for technology. It doesn't account for a lot of things. And so when we're talking about the requirements for a will, you have those form wills and we can kind of try on the back end to validate them, but the handwriting in has to be specific and you have to be able to read just the handwriting and determine whether or not that alone would constitute a will. It's not a fun process. You usually end up having to get witnesses to sign affidavits, and who knows where those witnesses have ended up. It's just, it can be very hard. And the language for what needs to be in what we call the witness attestation, just the block where it says, hey, I saw Billy sign his will, that has to be very specific. And the language for the notary also has to be very specific. It's not just whatever is going to work, whatever, it has to be what is in the statute or substantially similar. And my clerks, when I present wills, when they say substantially similar, it's just like synonyms. Like the context is all still the same, but you're using synonyms for different words. All of that has to be very specific and exact. And if it's not right, it's a pain to probate your will, or probate is the legal term for proving that a will is valid. Just the clerk is stamping off to say, yep, this will is Bobby Joe's last will and testament. Great.
Mm-hmm.
And if it's not done to a T, you're going to have an attorney probably spending thousands of dollars just to get to the point of proving that it's valid.
Right.
And then you have still the entire estate administration process.
It's expensive. Not the estate administration process can be expensive. Yeah. It shouldn't be if you have your documents done well.
And so that's why when we're talking about the Staples wills, the online wills, they can be great resources, but you still, even when you're in a divorce or a separation, you still want to make sure that you're talking to an attorney, because God forbid you do a Staples will, which looks perfectly valid, or a Staples power of attorney, which looks perfectly valid
to the untrained eye.
To the untrained eye, or to someone who just hasn't had to deal with it yet. You could have an attorney who doesn't do estate administration, who doesn't do estate planning, take a look and say, yeah, I think this is fine. It doesn't mean they're incompetent. It doesn't mean they don't know what they're doing. It just means they're not super versed with estate planning documents. And so you always want to make sure you just speak to someone who handles these types of documents. Now, we still have general practitioners here in North Carolina. I still work with a lot of general practitioners. And so your family law attorney might be able to help you draft these documents and get them done. But I would definitely recommend, if you are not working with an attorney yet for your separation and divorce, and you need your documents updated, to reach out to someone. We do these types of documents on flat fees a lot of the time. They're hourly when we need to think about it otherwise. But if you have an active family law matter with King Law, you can talk to your attorney about an internal referral, and you'll talk to someone like myself or Martie, who handles a lot of estate administration, estate planning matters, be able to help you, bridge the gap with valid documents where you don't have any questions and you got some peace of mind.
Exactly. And I think that pretty much covers, well, it doesn't even really touch the surface of family law and
not family law.
And where it intersects with, we could talk about it literally for days. That's why having an attorney is so important at the outset. We're not saying you got to buy this huge plan unless it's warranted, but it's good to, before you start, just get that consult and see if your situation is complex, but the chance of wills going bad are, I would almost say good, because it happens so much when you're doing those online. Whenever they say, oh, I used Rocket Lawyer, which they might be great. My experience with wills, I definitely trust. Oh, it's not good.
Yeah, my experience with the online or Staples resources is they're not curated enough to what you need.
And there's a disclaimer on it that says this may not be good for your state. And it's literally sold in North Carolina, and it's literally not following North Carolina law. So,
which is so frustrating. But yeah, again, you can always schedule a consultation with myself, Martie, or any member of our transactional attorney team, and we'll be more than happy to help guide you through the process of getting the documents that you need. Even if they're only placeholders, you at least have some peace of mind going through a
already difficult time.
Thanks for taking time to listen to us ramble on about how your domestic case can interplay with estate planning. If you have any questions or have any inquiries, you can definitely post on our social media on Facebook. If you would also like to schedule a consultation with myself, Martie, or any of our transactional team, you can call our client services team at 828-286-3332, and we would be happy to talk to you about your North Carolina estate planning needs. Thank you.
Thanks.